Welcome to tonight's event. Students, staff, council members of UTS, and all friends of UTS, and in particular the Australia-China Relations Institute. Tonight's event is titled, Does China Have the Rule of Law? What Australian businesses and the public should know. Now, to begin with the obvious, due to the COVID-19 outbreak and the need for social distancing, this event tonight is being hosted in the form of a webinar. Given that this is the first time we've tried this, it is possible that we may encounter some technical or procedural difficulties along the way. And I thank you in advance for your understanding if that were to arise. That said, I'm more concerned about Australia's national broadband network and whether that's going to hold up rather than our own competence in the technical side of running this webinar. So let's all keep our fingers crossed in that for that particular challenge. Shortly after tonight's event, a recording of the event, the audio of the event, will be uploaded to the ACRI website, where you can also find all of ACRI's research, including our updates on COVID-19. Now, despite tonight's delivery being in the form of an online webinar, it remains important and appropriate for me, on behalf of all those tuning in tonight, to acknowledge the Gadigal people of the Eora Nation, upon whose ancestral lands our UTS City campus stands. We pay our respects to elders past, present and emerging, acknowledging them as the traditional custodians of that land. My name is James Lawrenson and I'm the Director of the Australia-China Relations Institute here at UTS. UTS ACRI is an independent, non-partisan research institute. It has as its mission to inform Australia's engagement with China through substantive dialogue and research and analysis grounded in scholarly rigour. And tonight's discussion fits very well into that mission. We are delighted tonight to be joined by Colin Hawes. Colin is an associate professor in the UTS Law Faculty and the author of a brand new ACRI report titled Dealing with Commercial Legal Risks in the People's Republic of China, a primer for Australian businesses. That report is now available on the UTS ACRI website, should you wish to download it. Tonight we'll be talking about the commercial risks, but hopefully I'll be able to draw Colin out a bit more broadly around some of the legal challenges in the PRC that extend beyond just that narrow commercial focus. What I want to do right at the outset is to make it clear that Colin is perhaps Australia's leading academic legal expert on the legal system in the People's Republic of China. He has a truly impressive academic publication record. His research has appeared in all the leading scholarly journals in the field. His most recent research focuses on the Chinese corporate ecosystem, the creative interpretation of corporate law by Chinese judges, and the impact of technology, that's useful at a time like this, on the operation of the Chinese legal system. And like many academics at UTS, Colin is not merely someone who speaks from the ivory tower of a university. He has a background in practice. Prior to joining UTS, Colin practiced law in Vancouver. And also he regularly acts as an expert witness or legal consultant for China-related legal cases. Tonight's discussion around the rule of law is timely in China, is timely for a number of reasons. I just want to bring up one right at the outset, because this one's on my mind, and I think it's on the mind of many of those who have tuned in tonight. And it is the case of Dr. Yang Hengjun. Dr. Yang is an Australian citizen and a UTS alumnus who has been held in detention in China since January 2019. China's Foreign Ministry says that his legal rights have been and are being protected. And yet we also know that he has been held under conditions that our Foreign Minister, Australia's Foreign Minister Marise Payne, says are harsh. We also know he has not been granted consular access since December 30 last year, despite his vulnerability to outbreaks such as COVID-19. We also know he has not been permitted to see lawyers or his family members during his entire detention for more than 1 year. On March 24th, 2020, the Chinese government formally indicted Dr. Yang on suspicion of espionage. But the details of the charges against him remain vague. Foreign Minister Marise Payne has stated that this is unacceptable treatment. So, is this an example of the rule of law in China and how it is applied? I'll leave that as an open question for the time being, but it's one that we will come back to. I'm now going to turn to Colin and ask him to start us off with a presentation covering the main points of his report, perhaps a few beyond the report. I'll then ask Colin some questions myself, and following that, there'll be an opportunity for webinar attendees to interact with Colin as well. So you might want to think about some questions in advance that you would like Colin to comment on. You'll be able to pose questions to Colin via the Q&A tab at the bottom of your screen. Colin Hawes, it's over to you.
So, yeah, thanks, James, for that introduction, and thanks to UTS ACRI for inviting me to give this talk, and hope we can have a good discussion. I'm going to try and share my PowerPoint on the screen, so hopefully this will come up in a minute. We talked about technical issues, hopefully won't have any. Okay, and let's try that. So, hope you could see the first slide there. Does China have the rule of law? And what do Australians need to know about the Chinese legal system? I've broadened it slightly, not just business people, but Australians more broadly, because hopefully the audience is a bit broader tonight. And to answer those questions, they're very big questions, and I only have a short time, so I'll be brief. First, there are typical perceptions that you might hear about Chinese law from academics and other commentators. One is that China is a system where the rule of law does not apply. That was Nolan Sharkey, an Australian academic. Min Jinping has written a book about corruption in China. He said the evasion and violation of laws and regulations with impunity is an integral part of China's ecosystem of crony capitalism. And Martin Lee, a Hong Kong democracy advocate, has stated there's no extradition law between Hong Kong and China because there is no rule of law in China, where the Chinese Communist Party dictates who is innocent and who is guilty. Now, is this accurate? So first you need to decide what is rule of law. It's not easy to define. There's been books written on the subject. Ideally, in a democratic society, it would include most of the following points. It should maintain order, regulate political and civic transactions predictably. It should be transparent and fair. There should be equality before the law. You shouldn't have a special status just because in the law, just because you're rich or whatever. It should guarantee human and procedural rights, for example, not being arbitrarily arrested. Democratically legitimized bodies should make the laws. Executive power should be controlled through checks and balances, and the judiciary should be relatively independent and professional. So does China have all or any of these characteristics in its legal system? Let's talk about that. So it does have an extensive court system, and with thousands of courts at various levels, and right to the top you have the Supreme People's Court, which decides nationally important cases and also issues regulations and interpretations for all the other courts to follow. And you can usually appeal up to the next level of court if you're not satisfied with your judgments. And there's hundreds of thousands of judges and also lawyers who are arguing and deciding cases in these courts every day. So a typical example, just to give you a sense of how this might work in an ordinary case. This is a man called Sun Wanbao, and he represented the wife of another man called Xu in a divorce action. And the wife maybe got a better deal, and Mr. Xu was not happy. He then injured Mr. Sun with his BMW car. He bashed into his leg. So Sun then sued Mr. Xu, won damages for personal injury. Xu was then even more angry, and he paid this news agency to publish false stories insulting Sun, saying he wasn't a real lawyer, that he'd intimidated the judge and various other government officials in order to win his case, and he wasn't even really injured. He was faking his injuries, etc. So Mr. Sun demanded that the news agency retract these stories. They refused unless he paid them a large amount of money. So he sued the news agency for defamation for publishing this material online. And that's this case. And he actually won because the stories were obviously false and they'd been paid for them by this Mr. Xu. So he won 10,000 yuan in damages for emotional harm. So the interesting thing about this case is that a news agency, you may know, is in China is always going to be controlled by the government. Basically, the Communist Party's propaganda ministry supervises all news agencies, and they're tightly controlled by the government. But this ordinary citizen sued this news agency and he won. And that's because the news agency was not actually parroting any government kind of opinions here. They were just doing a commercial business and trying to raise some money on the side. And so obviously it doesn't have any political kind of ramifications, and Sun was able to win his lawsuit against this state agency. Now, this is just one of millions of cases that are brought every year in China. So there's been a huge increase in lawsuits in the last 30 years, up to about over 1 million civil lawsuits brought by ordinary Chinese people and corporations against other people, organizations, every year. So there's no cultural aversion to litigation in China anymore. And part of the reason for that is because the system does work pretty well in most cases. So one other development is that there's been a great increase in transparency, and that's improved the way the system works and made it more predictable. So you can now find judgments of all levels of Chinese courts from all over the country on this online database, and you can search them and you could find out how a specific court decided a case in your area where you have a dispute. If you're a lawyer or a plaintiff, you can then raise that case. When you go to that court, you can say, you decided this just a few months ago, you should follow, you should be consistent. And because these judgments are published online, it leads to much greater kind of consistency of the law. Judges know that they have to be more careful not to go against what their own court or higher level courts have decided, because otherwise they might be appealed and then their careers don't go ahead as they should. So there's about 89 million plus cases. You can see there's a circle, yellow circle at the bottom there. That's how many judgments they've put on. 89 million judgments have gone on there since about 2014. There's a huge amount of information about how the courts are deciding these cases. Not only judgments, but trials. Now it's very common for courts to live video stream their trials from beginning to end. And there's been around 6.5 million of those already streamed. And then they're kept on this open trials network and you can watch them. It's very boring, but boring is good in this case because it shows they're not editing them. They're like very long, hours long, and you can watch them from beginning to end with all the procedures. Civil law cases, here's a murder trial. You could watch that and see all the judges, the prosecution, the parties. And the video thing is really designed to make judges think carefully about following procedures in the trials, make sure they give the rights to the defendants to speak and their lawyers so that they're not just rushing through and ignoring people's procedural rights. So it's extremely important, and many other countries don't even do this. So China is ahead in some ways in terms of streaming trials online. So as you can see, huge improvements in transparency, which tend to lead to more predictability. Even back in 2006, only a few years ago, one scholar, Benjamin Liebman, had said, there is no comprehensive or even moderately comprehensive database of Chinese court opinions, but now we have almost 90 million court opinions or judgments available. In Australia, the biggest database is ACRI. They only have 850,000 judgments. So you can see how huge this database is, and the same with the trials. So this all sounds very good, and in fact, in China, the public has quite a good opinion of its legal system. So Peerenboom and He, two legal scholars, they carried out some surveys. They found that courts are generally perceived as effective and fair in China, despite the popular law about corruption. And business people in Shanghai and Nanjing were surveyed. 75% of them gave the court system a very high or at least average rating, which is better than surveys conducted in the UK, France, and Belgium. And the World Bank has ranked China very highly for contract enforcement. So they're 6th out of 190 economies in the 2019 survey. And that's better than the United States, United Kingdom, and Canada. Part of the reason those other countries score so low is because they take such a long time to resolve these contract or other litigation cases, maybe 2 or 3 years, and it's very expensive as well. Legal costs and lawyers' fees very high in those countries, whereas in China, most cases are decided within 3 to 6 months, and it's much cheaper. The legal costs are much cheaper on the whole. So it sounds great. There's so many improvements and people are satisfied with the system. But that doesn't mean there are no defects. And I guess for the second half of the presentation, I'm going to talk about those. And I call them distorting influences on the rule of law or the legal system. And I've identified 3 main ones: the political influence, personal relationships, and corruption. So I'll talk about each one and give some examples in turn. So political influence, the basic idea is that if you oppose the government in some public way, or if you cause any kind of social instability by your actions, then it's likely that the government or the Communist Party will come down hard on you, and they won't be worried about upholding. They won't be worried about upholding your legal rights in those kinds of political cases. So, for example, in 2015, about over 200 human rights lawyers were detained and kept, many for several months, some for a couple of years, and they were treated very badly in detention. Some of them were tortured. And why was that? It is basically trying to force them to stop bringing these human rights cases, because the government had found that these lawyers, apart from going to the courts, they were also encouraging their clients to group together and go and demonstrate in front of government offices, trying to get justice. They also were contacting the media and doing social media campaigns to get support for these interest groups. It was very justifiable, but the government saw this as risking or going against social stability. And so they decided this had to stop. And so they used this kind of intimidation tactic to stop them. Same with, you might have heard of Xinjiang, a Western China province or region, where there's a large Turkic Muslim ethnic minorities. And according to many international reports, over 1 million of the people there have been rounded up and put into re-education camps. And they don't have any legal rights there. They don't have legal representation, and they are supposedly educated and made to work until they show more support for the Communist Party and also learn to integrate better into the Han Chinese way. The reason for this is, according to the government, is that there were quite a few terrorist incidents involving people allegedly from this region setting off bombs in cities around China or other attacks on civilians in other cities. And so this is a kind of typical overreaction by the government, that they round up as many people as they can and basically show them, it's a show of force, and the legal rights go out the window in these kinds of cases. All the kind of procedural things that are in the Chinese criminal law, criminal procedure law, are kind of ignored. So that's political influences. If you get on the wrong side of the government, then your legal rights tend not to be upheld. Second one is personal relationships, or guanxi in Chinese. This is still relatively influential in some cases, especially those where an influential or powerful person in a local region has a family member that gets involved in a lawsuit, and then it's possible or likely that they might try to influence the judges and the courts to decide in favor of their personal relationship. So He Xin-he and Kuai Eng, they produced a paper, a survey of several courts, and they found quite a few cases where the judgments had been influenced in some way by personal relationships. So this is an example of a case where the plaintiff had lost his motorcycle. He claimed that it had been stolen in the parking lot of a strata corporation, and the defendant was the strata corporation. He was seeking compensation for their negligence, but the judge found there was no evidence or real evidence that his motorcycle had actually been stolen from that parking lot. So she was going to dismiss the case. But then the court vice president, her boss, basically in the court, told her, you better be careful here because this plaintiff is a family member of this local government official who is a director of the Political and Legal Affairs Committee of the region. Now that committee, they liaise between the local government and Communist Party and the courts, and they have a lot of influence over which judges are appointed and which are removed. And there's no tenure, life tenure for judges in China. They're removable by the government at the level of their court. So, so this judge, after hearing this, decided in favor of the plaintiff and ordered compensation because she was worried she would lose her job if she didn't do that. So, I mean, the good news is that this is not so common in most kinds of cases. It tends to be only people with very strong influence, like this director of legal affairs or someone who is a close family member of a judge. They might be able to influence their colleagues in the court. But most cases you don't have that kind of influence, right? So the third distorting influence is corruption, and that's a serious problem in China. China is ranked about 80th out of 168 countries in the Transparency International Survey of Corruption Perceptions. And the government knows this in China, and they've had this huge anti-corruption campaign since 2012. Over 2 million government officials have been disciplined or punished since then. Hundreds of thousands have been criminally prosecuted, sent to jail for sometimes for not hundreds of years, for life. And it goes right up to the highest levels of government. There's military generals, Supreme People's Court judges, Communist Party leaders like Zhou Yongkang, who was Politburo Standing Committee member, one of the top 7 leaders of China back in 2012-13. He was sent to jail for life for bribery and corruption. So it's a serious campaign going on. And part of the reason it's difficult is because you have these webs of corruption. Provincial government officials in dozens of them work together to hide this corruption and to work with state-owned enterprises to divert money away into their pockets. So it's very difficult to stamp this out without leaving a huge hole in the government. But they've been trying to do it for quite a while, but there's still a long way to go. And I'll give you an example in a minute of how it's so difficult, why it's so difficult, because it goes right up to the top levels of the government. But corruption is not necessarily always bad. It can sometimes have a positive impact in the sense that the law sometimes doesn't keep up with the rapid changes in Chinese society. So in Shenzhen, a city, it started as a town of only 30,000 and it grew to 14 million plus residents by about 2010. And so in 30 years, it had this massive growth, millions of people moving in to find jobs. This city is right next to Hong Kong. It's a special economic zone, so the growth area. So around 50% of the properties in Shenzhen were developed illegally. So this massive city, 50%. And the reason for that was because the zoning laws couldn't keep up and the government was not able to approve so many new housing developments going up. So the local residents and banks and lawyers and real estate developers, they all privately worked together and they paid off local district officials to turn a blind eye to the fact that these land had not been properly zoned for development. And they built these apartments and then sold them off on the market, you know, for which benefited all the local residents who collectively owned this land previously. So, and there's such a huge scale that the government really can't go and knock down all these half the houses in Shenzhen. So basically now they're starting to legalize this, these illegally developed properties. So you can see that sometimes corruption is the only way to deal with a rapidly changing society where the law just can't keep up. But other kinds of corruption is predatory. It really harms ordinary people's interests at their expense. There's no real positive side to it. And I'll finish with an example called the billion yuan mining rights case, just to show you what the problem is like. Kaichilai Corporation is a private company, and they wanted to develop or explore for coal on this property in Shanxi province in northwest China. And so they signed a contract with the owner, which was Mining Exploration Institute, MEI, a state agency under the Shanxi government. And the contract said that Kaichilai could keep the proceeds from 80% of any coal that they discovered on this property, and the other 20% would go to MEI. So they developed, they explored the land and they found this huge deposit of coal, which was worth about 1 billion yuan, about 200 million Australian dollars. And then MEI and the local Shanxi government got cold feet and said, we don't want to share 80% of our revenues with this corporation. So they signed another contract with Ye Corporation, a Hong Kong private company controlled by a mysterious Chinese lady who had close personal ties to several Shanxi government officials. And it seems like this was a way to divert money from this mining coal sales down to Hong Kong and then funnel it into these officials' accounts in some way. So a corrupt kind of deal. Kaichilai Corporation was obviously upset losing all this profit, so they sued MEI in the court. And after about 10 years of going up and down the chain, several retrials, there was a lot of interference by the Shanxi government and intimidation of Kaichilai's CEO. But eventually it did reach the Supreme People's Court for the final judgment, right up in Beijing. And they decided for Kaichilai Corporation, they said they had a valid contract, but they didn't give any order to enforce the judgment. They didn't give any saying how much compensation they could have, which was very strange, and so it was unenforceable. In 2018, a judge from the Supreme People's Court called Wang Linqing, he publicly exposed on social media that the case which he had been, in theory, in charge of, the Chief Justice of the Supreme People's Court had interfered in it, and the case file had been stolen from Judge Wang's office, and he had basically pushed off this case, and someone else had written the judgment which was different from what he had intended, and it ended up with Kai Chi-lai losing out. After he made these claims in public, there was a government inquiry, and it was headed by China's anti-corruption agency, but they found that Judge Wang had stolen the case file from his own office, which is completely ridiculous. And there's many other really strange, ludicrous things in their report, which was published. So much so that people really, especially overseas Chinese media, couldn't help but think this was a cover-up. And one reason for this is that the Politburo Standing Committee member called Zhao Leji, one of the senior Chinese leaders, he was and still is the director of the anti-corruption agency, which led this inquiry. He was also previously the party secretary, the leader of Shanxi province back in 2007 to 2012, when they were involved in this lawsuit and signing the rights away to this Hong Kong corporation. And some overseas Chinese media have said that he may have personally benefited from that deal. So you can see that when there's some kind of corruption at very high levels of government, it's going to be very difficult for the cases to be decided fairly when they can interfere at such a high level. Even the Supreme People's Court may not be immune to this kind of interference. So, as a conclusion, I want to just mention how the rule of law and these distorting influences interact together. It's not a simple case of you have party control or political control at the top, and then they tell the courts what to do, and everybody just listens to them. There are competing interests here, and often those other influences, the corruption, the personal relationships of people lower down the chain, they may also be government officials, but they undermine parties' control and they act in their own self-interests, not necessarily in the Chinese government's interests or the party's interests. Like that case we just talked about, there's no way to see that as benefiting the Chinese government or the party. In fact, it led to a lot of cynicism, I think, among people that the Supreme People's Court itself was being wrongly interfered with. And many other of these corruption cases are like that. It leads to a public kind of doubt as to whether the government is following the law when it should be. And it's not for political reasons, it's for personal gain. At the same time, corruption or unlawful behavior is sometimes necessary, like we saw in Shenzhen, because the law doesn't always keep up with the changes in society. It just can't keep up with demand. And then we also do see courts and judges trying to resist these external pressures, like the judge Wang Linqing. He tried to decide this case fairly, despite all the risks of being maybe framed. In the end, the forces against him were too powerful, but many judges are trying to resist these external pressures at lower levels. And you can just hope that eventually the system will be improved enough so that the distorting influences are not so able to undermine the rule of law, as they have been, as the rule of law has been working quite well in many cases that don't involve those influences. So that's a basic kind of introduction to rule of law and distorting influences, and I'll be happy to deal with any questions and comments that you may have.
Thank you very much, Colin. I'll let you exit out of that PowerPoint presentation, and then I'll start off. I think that last slide captured the key points, Colin. This is complicated. There's no simple answer to the question, does China have rule of law? That presentation was wide-ranging, it was complex, multidimensional, about whether China does in fact have the rule of law or not. Your report for UTS ACRI, that's on the ACRI website now, focuses on commercial risks. I am conscious that amongst our webinar attendees tonight, there'll be people who've tuned in for precisely those reasons. They'll have a commercial focus. And there's other people who'll have a broader focus about rule of law in China and how it applies to different areas of society, including areas like human rights. So if you don't mind, I might offer up a suite of questions that try and cover that very broad territory. And then after that, we'll be keen to I'll put some questions to you from our webinar attendees. Can I start off by going back to that particular case that I raised in the introduction about Yang Hengjun, Dr. Yang Hengjun, an Australian citizen and a UTS alumnus. Now, China's Foreign Ministry, when they've been asked by Australian journalists about his treatment, they say that his legal rights are being protected, and they will be protected throughout his, as he goes through the Chinese legal system. Now, Colin, in the introduction, I also mentioned a few other very disconcerting facts associated with his treatment. So my question for you is, should we take any comfort at all when the Chinese Foreign Ministry says to Australians that Dr. Yang Hengjun, his legal rights will be protected, or we should, have some serious doubts about whether that will in fact be the case?
Yeah, so unfortunately, people who have previously been detained in China, including foreign nationals, they have had a similar kind of experience where the Chinese Foreign Ministry has said their legal rights are being respected, but when they get out of China, they make it clear that their rights were not actually being respected. They were not treated well. They were often, interrogated for hours at a time, sometimes deprived of sleep, sometimes their family members or loved ones were threatened if they were in China. So you can't really, I think the Foreign Ministry has to make a standard kind of response to those kinds of questions, but they haven't necessarily looked into the individual cases and found out what's really happening. And obviously they're not going to say that the person is being mistreated. So to get the real situation, you have to wait until the person gets out, find out what really happened. And I don't think the people who have got out previously, like there have been some NGO leaders, foreign NGO leaders who've got out, they are quite reliable people. They're not anti-China people. So I think what they say is quite, can be believed. Also, there is a trend for these political, as I said, political cases where people are seen as opposing the Chinese government. And Dr. Yang, I think, had some, blog where he called for changes to the Chinese government, etc. They have been treated in similar ways, in like the human rights lawyers I talked about. Some of them were into political change as well, and definitely they have been treated very badly. I mean, the only positive development is that the Chinese government is bringing in more laws to try and protect suspects' rights, including those who are, caught up in state security or anti-corruption investigations. Previously, there was no law on how they should be treated under those kind of investigations, but they brought in a new law in 2018, supervision law, which has basically said that you cannot torture, you cannot treat people in those kind of situations. So they're going to have to be more careful if they're going to follow their own law.
Right.
It's very difficult to monitor and to find out what's happening if if you're not actually, I mean, what is the check and balance here? Who's gonna monitor these people when they do these interrogations?
Yeah, yeah. So, Colin, can I say a fairly safe takeaway for us tonight is that in this case, we're clearly not, unfortunately, on the verge, or we're not expecting to be on the verge of Dr. Yang being released and being able to tell his own story. So when Marise Payne uses words like unacceptable treatment, harsh conditions, we should put some weight in that assessment. Is that fair enough?
Yes, and because the consular officials have met with Mr. Yang last year, and he has told them what's happened, and I don't see why we shouldn't believe that. Secondly, I should add that it's important that the Australian government does continue to raise this case with the Chinese authorities and make public statements like that, because all those people who have come out of China after that kind of experience, they have said it was helpful. Their treatment improved when there were when there was a kind of international kind of awareness and public kind of awareness of what was happening to them. So, you know, I think it's important that those statements are made as long as they are accurate. Yeah.
Right. Okay. Now, aside from Yang Hengjun, I might just stay with this issue of human rights for a bit longer. There's also 2 Canadian citizens detained in China. They have been detained for more than a year and a half now. Now, this case seems to me to be particularly disturbing because, at least to me, it appears as hostage diplomacy. And what I mean by that is those 2 Canadian citizens were detained immediately following Canada detaining a Chinese citizen, in that case, an executive of the Chinese tech company Huawei, at the request of US authorities. Now, you probably know this better than me, but my understanding is that Canada says, well, we're just following the rule of law. That's all we were doing. China doesn't buy it. It comes along and says that politics, not the rule of law, is at play here. And remembering that in the end, at the heart of this, we've got 2 Canadian citizens detained for more than a year and a half who don't have access to lawyers or their families. So let's keep them at the center of this story. So how do you weigh these arguments from both sides? I mean, is the rule of law in a liberal democracy like Canada and Australia pure, or is there some complicating factors here?
Yeah, so I don't, I mean, I have looked into that case very carefully, and I've published quite a bit about Huawei and its corporate governance and its history. In various lengthy articles. So I don't think the Canadian government has a political agenda here, and they were not necessarily opposed to the Huawei setting up in its business in China. In Canada, sorry, but they were really just following what the Americans had asked them to do, which was to arrest a so-called criminal suspect. Having said that, I do believe there's been a strong political campaign against Huawei by the American government, and a lot of their statements about Huawei have been very inaccurate and misleading. And the cases against Huawei, and especially against Meng Wanzhou, the CFO, I think are very weak. I've looked at the evidence, and there doesn't seem to be much at all to bring a criminal prosecution against her. So I do feel that the Canadian government could have, got out of this by just accidentally letting her slip through the net in the first place. But having done that, having arrested her, and now they have to go through a rule of law system because that's the way Canada works. And the Chinese government does not really seem to understand that. If Canada just released Meng Wanzhou for political reasons, then that would go against the Canadian government's whole idea of rule of law. It's not like in China where if a senior government leader or the party says you should release this person, then they get released, you know. So in a way, Canada has to go through this whole long legal process, even though it's taking a long time, and even though it means that their own two citizens are held in China for a long time as well. It's I guess a kind of principle that they're sticking to.
Mm.
They just shouldn't have got involved in it in the first place, really.
Well, I believe there might have been a Canadian diplomat who made that same argument, but anyhow. Okay, Colin, human rights cases aside, another area, and this is more of a commercial area where I hear a lot of skepticism expressed about the rule of law in China, is around the protection of intellectual property. So the basic argument here is that it's a priority for the Chinese government that China moves up industrial value chains. That's the only way its citizens can achieve a higher standard of living. And so, particularly from American sources, American government sources, you'll often hear the line that, well, if China has to steal intellectual property to move up the value chain, then that's what it'll do. And indeed, the FBI has been quite vocal publicly that a lot of their corporate espionage cases can be traced back to China. So what do you make of that argument? I mean, should Australian companies, for example, stay away from the Chinese market because their intellectual property could be or is likely to be knocked off? Or in the case that you and I are in a university setting, should Australian universities not collaborate on research with Chinese counterparts because the knowledge that gets created might be stolen and that intellectual property not protected? So what's your take on that particular area?
Yeah, so I would say that the US government seems to be a bit out of date in its characterization of China's IP record. And so there's been actually quite huge improvements in protection of intellectual property in China for, you know, foreigners as well as Chinese corporations. And I think the best thing, if you want to find out more about that, is to read. There's a very good article by a scholar called Dan Prudhomme. He's based in France, and he's an intellectual property law expert and also a China law expert. He wrote an article in the Harvard Business Review back around October or November called 3 Myths About IP Protection in China. And if anyone's interested, you can email me and I could send you the link. So basically he was saying that this idea that China is somehow stealing intellectual property has been greatly exaggerated. That if you survey American businesses in China, these are the American Chamber of Commerce in China has surveyed its own members in China, and intellectual property, things like hacking, Chinese employees stealing their business secrets, trade secrets. This is a very low priority in those surveys for them. It's not something that they have really are so worried about. And there's other issues that they're more worried about, such as market access in China and not being discriminated against in terms of selling their products and those kind of things. But this whole idea that IP cannot be protected in China is just what he calls a myth. And in fact, the system there works better than many other European countries and sometimes better than in the US. So it's quite surprising that an expert would say that those kind of things, but he gives plenty of evidence to back it up. And so I think Australian corporations, universities, they obviously need to be careful, just as they would with any other partner, about their IP. They need to have good cyber security and things like that, protections. But if you don't really start working with advanced Chinese corporations and research institutes, you might find that we're falling behind actually, because some of the most advanced technology now is being produced in China. We mentioned Huawei, they actually have about 50,000 patents now for new inventions or other kind of processes, and about 10,000 of those are in the United States. They've been approved for patents for about 10,000 inventions. So if they were stealing all that intellectual property, then I don't think the US Patent Office would be approving their applications. So obviously you have to be cautious, but at the same time, you can't miss out on doing kind of collaborations with advanced Chinese technology firms.
That seems to have been reflected in the extent to which Australian university researchers are collaborating with Chinese partners. ACRI has looked at that exact topic and found that last year, there were more Australian scientific publications that featured a Chinese co-author than an American one. Now, Australian universities aren't in the business of charity, so you'd have to be assuming that those collaborations are based on the contributions that both sides are making. Okay, one more question from me, Colin, maybe two. We'll see how we go for time. I wanted to ask you a question about the rule of law in terms of Australian public policy. So we've sort of covered human rights, corporate issues. Now I'd like to move on to public policy. This is an area where I see questions in Australia around the rule of law in China being reflected in Australian public policy decisions. I think specifically of the decision to exclude Huawei from the rollout of Australia's 5G network. There were two rule of law questions raised. One was that an Australian interpretation of China's national intelligence law was that a company like Huawei would be obliged to cooperate with Chinese intelligence agencies. But even if you left that aside, there was this was the justification, and I'll read it directly just so I don't get the quote wrong, the justification that the Australian government put up. It said it did not want involvement of vendors who are likely to be subject to extrajudicial directions from a foreign government. End quote. Now, China wasn't mentioned, but it's not hard to work out that clearly it was Chinese tech companies. It's pretty much only Chinese tech companies and two other ones who are capable of supplying 5G equipment. So Chinese tech companies were clearly at the forefront of Australian policy makers' minds. My question is not so much about revisiting the Huawei decision, but reflecting on this general issue that Australian policymakers clearly have concerns around the rule of law in China. So do you think this is going to be a challenge in more and more areas of the Australia-China relationship? At UTS ACRI, we're all about the bilateral relationship rather than being a China Studies Centre per se. So what do you see as the challenges for the bilateral relationship?
Well, yeah, I think it's very difficult for the Australian government to allay its suspicions about China because of some of the cases that I've mentioned, even though they are not always involving Australians, and very few Australians get involved in Chinese law. But just one case can really damage that kind of impression of the Chinese legal system, like Yang Hengjun. Why is he being arrested? So that can undo like millions of cases that have been decided fairly in China under its legal system. And it obviously, because of the publicity, because of the way that the Chinese government denies that anything is wrong, that has a very major impact on the relationship and the ability of Australian politicians to promote good relations with China. And so I think there's an outsized impact that maybe the Chinese government doesn't quite realize of some individual cases involving foreigners or some groups like the people in Xinjiang. It really has reduced people's trust or ability to trust the Chinese government. And then that has a sort of roll-on impact. Like, for example, in the United States now, Chinese students are barred from certain kind of programs involving high technology because of the suspicion that the Chinese government might be trying to get trade secrets through students. And so that impacts education, and that might have a similar kind of impact in Australia if the government has this kind of suspicion. And similar with other kinds of, like the foreign influence law that the Australian government brought in, it means that it's going to be more difficult for people with ties to China, even if they're not necessarily pro-China, but they're just Australian Chinese people who have experience of trading with China, dealing with China. They might feel a chilling effect and not be able to contribute so much to the policy dialogue that we need to have with such a large power. So it sort of removes the opportunity to engage, I think, when the Chinese government does these kinds of, you know, impulsive, what looks like impulsive kind of actions. And I'm not sure how it really benefits the Chinese government either. Like, why can't they deal with somebody who's saying we should have political reform? I don't know why they can't deal with that, you know.
Okay, Colin, just sneak in one final question, then I'll go to questions from our audience. I can see some numbers popping up at the bottom of my screen here. The final question from me is this. I'm an economist, and one thing I've learned about studying the Chinese economy for a long time, since the mid-1990s, is that trends that may last for 5 years don't necessarily last for 10 years. I remember there's been times where we've thought, well, the Chinese economy is on a permanent trend towards greater marketization. Well, that trend has certainly been challenged in recent years. Now, I think your presentation tonight and the report for ACRI on a website now gives us an up-to-date assessment of where things, or where key developments around the rule of law are headed in China. But how do you see things unfolding in the future? I'm not asking you to have a crystal ball here, but I'm asking you to consider a possible future. For example, say China's economy tanked for whatever reason, and the Chinese government's legitimacy was being questioned by a broader swathe of the Chinese populace. Obviously not free and open elections in China, so a lot of legitimacy is tied to economic growth. Say that started to unravel. Is it possible that we might have a future where the rule of law could become one of the first victims, despite some improvements over the past decade?
Yeah, so I mean, I think you would probably go back to the last time when there was a massive social disorder in China, which was 1989, Tiananmen Square incident, and that's an example where there was economic kind of instability and then protests on the street, and then the government basically cracked down and people's legal rights were again forgotten. It was a political kind of issue. People's legal rights were pretty much forgotten. A lot of them were arrested and kept in prison for many years. Some of them escaped overseas and they still can't go back, some of the leaders of the student movement. So that would definitely be the default kind of behavior of the Chinese government if they were faced with major social instability, is to crack down in using, whether it's the military or police, etc. At the same time, what's interesting, I find, is that even though we're having a bit of this massive anti-corruption movement, and there's a sort of bit of repression in terms of freedom of expression under the Xi Jinping regime, at the same time, they're still going ahead with legal reforms over that same period. Behind the surface, it's quietly happening, like, as I said, more rights for criminal suspects, more kind of protections for people being caught up in these kinds of investigations by anti-corruption. And part of the reason maybe is that some of the senior leaders of China, they think, oh, it might be me next. I might be caught up in some investigation. Maybe I need to make sure I'm using my influence over certain legal process, legal reform. I need to make sure that some of these protections are in place. Whatever the reason is, there is a definite trend towards stronger legal protections and institutions. Whether they always follow those, and especially in time of crisis, probably not. But over the long term, the trend is going in the right direction in terms of those protections. So I guess I just hope that there won't be some massive crisis like you're talking about, because I do believe over the longer term, the law will start to play, rule of law will start to play an even stronger role than it has.
Okay, thanks, Colin. Let me now go to some of the questions that are on my screen from our webinar attendees tonight. Now, these are very wide-ranging questions. I'll just pose them to you, and you feel free to answer them to the extent that you feel able to do so. So we've got one here from Brendan, who asks this: are there any unique distortions or influences that affect how Chinese enterprises attempt to enforce overseas debt owed to them? So I guess we've got a Chinese company in China, I'm assuming. They're owed money from overseas. Are there any influences or distortions, unique influences or distortions on how they might attempt to enforce that contract? Is that in your realm of expertise?
Yeah, well, actually, I have a section on that in my report, so maybe the questioner Brendan can read that part about if you are owing money to a Chinese corporation. I think that's the situation we're talking about here, or you have some kind of contract dispute where you are refusing to pay because you think there was some problem with their performance of a contract. That is a very risky situation, because there have been a lot of, basically what you might call informal detentions of foreign business managers or executives in China before they can leave the country. What usually happens is the Chinese side to the contract invites this foreign manager, to negotiate, and then they just use local kind of thugs or law enforcement that they paid off to detain these foreign executives in a hotel until they agree to pay off the debt or pay the contract. So the advice of most lawyers in China is, if you think you might be getting into that kind of debt situation or refusing to pay on a contract, you should not go to China. If you can possibly help it, you should not. You should leave before you get into that situation,
Right.
because it's quite common. There have been apparently several cases a week in recent years of foreign managers being detained in this way, informally detained.
Okay.
So that's unique, I think. Well, whether it's unique, but it's quite distinctive in China compared to other countries.
Right, and just to note, there's a section in your report for UTS ACRI on that topic. So Brendan, you might want to check that out as well. Carl, the next question, the next question is from Carl, and it's a really fundamental one, I think. So I'd like to ask it to you. Carl asks, is it possible to have rule of law as opposed to rule by law, which I understand is a formulation that the Chinese government is fond of? So is it possible to have rule of law as opposed to rule by law when there is no separation of powers? Big question.
Right. So the term in Chinese, they use the term 法治, which some people translate rule of law and some people translate rule by law, depending on what they think of the Chinese system, because it can be translated either way. So is it possible to have it without separation of powers? You need to have some kind of, I guess, ability for judges to decide cases based on the law without interference. So you do need some kind of independence of the courts. The Chinese government would argue that the courts need to be supervised by the government just to make sure they don't go against, cause kind of social instability or go against the government's values, and it's been like that for ever since the communists came to power, basically in 1949. There was a deep suspicion of judges as sort of representatives of a bourgeois class that couldn't be trusted. And so I don't think that kind of supervision system is going to go out anytime soon. In theory, they're not supposed to interfere in individual cases, but as I said, when you have power, you're likely to do it. And so I don't think you can have a democratic, liberal rule of law system without separation of powers. But whether you can have some kind of system where there's a check and balance on the party's own power, maybe that's possible if you had an independent, a truly independent corruption commission, which they don't yet have, but which has a check and balance on parties' power and the way they interfere in courts. Maybe that might be an alternative system.
Okay, thanks, Colin. This next question is more of a purely commercial one rather than a rule of law one, but I know you've got a lot of experience around corporate governance in Chinese corporates. So let me put it to you. It's from Dave. And if it's a bit out of your area, feel free to say so. He asks, Dave asks, do you think there is a possibility foreign regulators and investors will start to become more aware and wary of the role of the CCP as having ultimate control of Chinese companies, including those that are publicly listed? So I guess it's a big question. It could extend into your assessment of the extent to which the Chinese Communist Party does have control of Chinese companies, but even if, you know, feel free to comment on that. But do you think there's a growing awareness or wariness, as Dave says, of that in overseas markets?
Well, yeah, I mean, it's definitely influenced some governments' attitudes towards Chinese corporations in terms of acquiring foreign companies or acquiring certain agricultural or other businesses overseas, etc., or like Huawei buying up some high-tech companies overseas, because in theory, the Chinese Communist Party might be able to influence those corporations and somehow undermine foreign interests. You do have to distinguish, you still have to distinguish between state-owned firms and private firms in China. In state-owned firms, the Communist Party has a very clear role in management, and the senior executives of state-owned enterprises are chosen by the Communist Party's organization department, which is a kind of the same personnel department that chooses Chinese government officials. So definitely in state-owned enterprises, there is strong political influence from the Communist Party. In private companies, they do have to set up Communist Party branches, but they're not part of the management structure. They are designed to allow employees who are Communist Party members to kind of join together and meet together and promote the party's kind of policies, but they're not making decisions for the corporation. And it's a different kind of corporate governance structure. So, and in many private companies I've found in my research, and in some, I've read some surveys by Chinese scholars as well, they found in private corporations, the party organization has basically been co-opted by the party management, by the corporation's management. So in one big glass company called Fuyao Glass Company, which was a subject of an American documentary, I think it's called Made in America or something like that. It won an Oscar recently for best documentary. So that company, Fuyao Glass, they showed the Communist Party secretary was actually of the company was actually the brother of the CEO who owned the company, and and he was also the labor union director. So you can see it's a family business basically, but he's just playing the role of the Communist Party branch secretary because they want to show that they're, filling in the dots. But it's not the government controlling that company. It's the company saying, okay, we have a party branch. Let's staff it with our own people. So, it's a bit more complicated than people make out. It's not a question of party telling companies what to do all the time. Sometimes it's the other way around, which is quite surprising when you think, oh, Communist Party has absolute power, but at the local level, maybe it's not quite so simple as that.
Okay, thank you. Colin, the next one, I'm really testing your legal limits tonight. This question, I want to ask it to you because I think it's a question that many people will have an interest in. It's from CC, and CC asks, is the joint declaration between China and Britain on setting up Hong Kong as an SAR for 50 years just a promise? Or are there legal obligations involved? Legal question, Colin. Are you happy to take that one?
Well, I must admit, I'm not an expert on Hong Kong basic law, which is what you were just talking about. And it's not really a commercial kind of area. Having said that, it was the equivalent of a treaty signed between two nations, and it was approved, as I understand it, it was approved by the Chinese government's, National People's Congress, and which is their highest lawmaking body. So, in theory, the Chinese government should respect that. But the problem is that, like many Chinese laws as well, that the terms of the law are relatively vague, and so they're open to interpretation, and Hong Kong people have a different interpretation than the Chinese government about how independent Hong Kong should be within that 50-year period, and that's part of the problem here that causes a lot of the social tension and the demonstrations in Hong Kong, that the people in Hong Kong feel that promises were made by the Chinese government to give them universal voting, and then those promises were broken. So there is a legal document there that has binding force, but the difficulty comes when you interpret it, like with many, constitutional type laws. It's people don't always agree what it means.
Okay, thanks, Colin. Colin, I'm conscious we've only got a couple more minutes to wrap this up. I might finish with this question. I do apologise to the other webinar attendees who've asked questions that I'm not going to be able to get to. But I want to finish on this one because it kind of brings us right back to the crux of this discussion tonight and the topic of your report for UTS ACRI on the commercial risks facing Australian companies in China, what they need to know. And it's from Jerome. He asked this question very plainly. Colin, after all that you've researched, after all that you've written, our discussion tonight, will Australian businesses really get a fair hearing before an unbiased arbitrator in China, in the event that they're caught up in a legal dispute?
Yeah, so I wouldn't say, arbitration is different from a court. So I'll talk about the courts. There are also arbitration hearings, but they're a bit different. They're more private dispute resolution. So let's talk about the courts. You're much more likely as an Australian corporation to get a fair hearing now than you would have done 20 or 30 years ago, because the judges tend to be more professional. They know more about the law, and the lawyers also, Chinese lawyers, if you choose the right law firm, they can make a very strong case, and they may also have good, strong connections with the local government and with the local courts, and that will help as well. And so foreign corporations often do win cases in China and get damages, especially in commercial cases. Obviously, the main problem is going to be if you're going up against a very powerful, a government leader or a corporation that is controlled by a family of a government leader, then you're unlikely to win the case because of the kind of influences I talked about. So you do have to assess who you're going up against, what kind of connections they have. But in most commercial cases, you're more likely to get a fair hearing. And if you choose the right law firm, if you choose the right place to bring the lawsuit in China, then possibly you might get in other countries even.
Right.
So, it takes a bit of a kind of judgment call as to what kind of opponent you're dealing with.
Associate Professor Colin Hawes, thank you very much for joining us tonight in this UTS ACRI webinar, and many thanks for authoring that report that is now on our website. To our webinar attendees, I'd just like to remind you the recording of tonight's webinar will be made available on our website, where you'll also find all of UTS ACRI's research and commentary. And I just particularly want to let you know, we've got a real focus on COVID-19, just like many other places do at the moment, particularly on the economic side of the Australia-China relationship. So for those of you who are interested, please do check out the ACRI website for those outputs. Thank you very much for joining us. I look forward to seeing you probably at another webinar rather than a physical meeting in the next couple of months. Thank you. Good night.
Thank you. Bye.